A teacher accused of secret meetups, FaceTimes, and messages with a 14-year-old student, and that may just be the beginning. Sadie Flores is a wife, a mom, and a teacher now accused of grooming a child. What police say a parent found when they allegedly went through their child's phone that made authorities get involved and put a new law that is just...
A parent went through their daughter's phone. That's how this starts. Not a raid, not a leak. A mother scrolling through messages she was never supposed to see and finding a name that didn't belong there.
As to how someone gets into the position that Flores is now in, facing allegations, and they are just allegations at this point. She's innocent until proven guilty, but they are allegations accusing her of a potential sex crime with
her daughter's teacher. Sadie Flores taught special education at Graves County Middle School in Kentucky.
Last school year, and you can see her name prominently displayed outside her classroom. Flores was a teacher at Graves County Middle School. It's a public school located in a rural part of Kentucky, and it's in the southwest corner of the state, not far from the Tennessee border. And
she coached volleyball. She was married to her high school sweetheart, had a young daughter of her own, posted about church on Sundays. If you scrolled her Facebook page the week before her arrest, you'd have seen exactly what everyone wants to see from the person teaching their kid.
Potential late-night conversations between a teacher and a student. Now, there is a twist to this case. Kentucky has a new law that is related to grooming, and this law just went into effect last month. It's weeks old, and the law is being applied here as a felony. And before...
Now she's in a jail cell, and the law used to put her there didn't even exist a month before her arrest. Here's the thing, though. I need you to sit with that for a second because it matters. Kentucky's grooming law went into effect on July 15th of this year. Weeks, not years, weeks before Flores was charged under it. And that timing isn't a coincidence. It's the whole reason this case is getting attention beyond Graves County. So what actually happened?
Arrest. So here's the uniform citation that we just got in. It says the parent of a 14-year-old student went through their phone and reportedly found messages between her child and Flores. Investigators say the messages, quote, were determined that were not to be of a legitimate purpose and were not school related. But there's more. The parent also says there were multiple incoming phone calls that were later identified as FaceTimes that had occurred
According to the citation obtained in this case, a parent found messages between her 14-year-old and Flores. Investigators say those messages weren't school-related. There were FaceTime calls late at night the parent didn't know about, and investigators allege the two met in person once before a school function Flores wasn't even part of.
What authorities potentially find on those accounts? Now, Flores is charged with grooming a minor. That is a Class D felony in Kentucky, and that law is less than 1 month old. The crime that Flores is charged with became a crime on July 15th. That's it. It defines grooming as an adult over the age of 18 targeting a minor, quote, with the intent to entice, coerce, solicit, or induce the minor to engage in sex.
That's what's in the paperwork. Not a confession, not a conviction. An allegation, backed by a citation that a grand jury or a courtroom still has to weigh. And look, I want to be straight with you about something. Flores has not been convicted of anything. She's presumed innocent, same as anyone facing charges in this country. And that presumption doesn't get suspended just because the accusation is ugly. If this case falls apart under cross-examination, if the messages turn out to mean something other than what the citation claims, that matters just as much as if they don't. I'm not going to pretend otherwise to make this story hit harder. But here's where it gets interesting.
Fine of up to $10,000. According to WKRC-TV, this grooming law was proposed after a music pastor sexually abused a young boy in northern Kentucky. Authorities say that relationship started with the pastor building a relationship, grooming the student online before things became...
This law exists because of a different case entirely. A music pastor in northern Kentucky groomed and then abused a young boy. And lawmakers looked at that case and realized something uncomfortable. Under the old statute, prosecutors couldn't always act until things had already gone physical. By then, it's too late. So they wrote a law that lets the state step in earlier, at the relationship building stage, before anything crosses into abuse. Kentucky became one of 18 states that now criminalizes grooming specifically, separate from the abuse itself.
Well, so my hat's off to the legislature for coming up with a step towards trying to protect kids. Anytime the legislature is trying to do something proactive to prevent harm to children or vulnerable people, my hat's off to the Kentucky legislature for putting something in place like this.
Now that sounds good on paper. Everyone wants a law that stops this before it starts. But a defense attorney who works these cases pointed something out that I haven't stopped thinking about. The law uses the word intimate to describe the kind of relationship that counts as criminal grooming.
I think you do too. I've got a copy of the law printed out here. And a lot of times when legislators write a law, they will actually have a definition for a word like that, which can have so many meanings. The word intimate can have a ton of meanings. I mean, it can be an intimate sexual relationship, or it can be an an intimate relationship, just between friends, right? So in humanity, the definition of intimate can have several meanings. It's unusual to me that I don't see a definition of intimate in the statutory scheme.
And nowhere in the statute is that word actually defined, which means the same law built to protect a 14-year-old could, in theory, get applied to a teacher who was just being kind to a struggling kid in a way that never crossed any real line. That's not a hypothetical. That's the exact tension this law creates the moment it leaves the legislature and lands in a courtroom. I'll be honest with you. This one sits differently with me than most of the cases we cover here. Because most of us had a teacher like this growing up. Someone who noticed you were having a hard year and checked in a little more than the others did.
The victim, the impact on families, and even the families, I think of the suspect, and the impact on them. I mean, these rock lives, but I also think of when I was growing up, if there was, say, a kid on my high school football team that had a tough situation at home, and you had a coach that, would be the person to take them to practice or even in some cases help, with home.
Someone who drove you home once or texted you about how a test went. None of that made them a predator. And the idea that a brand new, still undefined law could someday sweep up someone like that, someone who never meant a single thing by it, sits uncomfortably next to the very real fact that this same law might be exactly what stops the next case before a child gets hurt. Both things can be true. That's what makes this hard. So we're left with two questions running side by side. Did Sadie Flores actually do what the citation alleges? And separately, is a month-old law with an undefined word sitting at its legal center strong enough to survive the scrutiny it's about to get?
They pick strong cases. If it's a weak case, the step for the defense lawyer would be to file a motion to declare the statute unconstitutional because it's vague. Vagueness in a statute can be a basis for a criminal defense lawyer to challenge a statute and say, hey, it's unconstitutionally vague. Nobody can know what intimate communication is. It's hard for anybody to know.
Because if a defense attorney successfully argues this statute is unconstitutionally vague, this case doesn't just affect Flores. It could gut the tool Kentucky just built to catch the next one. The school district put out a statement, the kind you'd expect. Full cooperation, highest priority, safety of our students. Words districts say every single time this happens, because they have to. What they didn't say, and what nobody said publicly yet, is whether this was the first sign of a pattern, or whether an entire career and a family's life just got upended by a law so new that even the attorneys handling it aren't sure exactly where its edges are. Investigators are still going through her devices. More could come out, or nothing more might. That's the uncomfortable truth about a case this early.
Of some sort.
Yeah, and it's just disturbing case just based off the small information that we have at this point. It appears from the law that the victim is either 14 or younger. We'll see how this case plays out and the new information that comes out.
We don't get the ending yet. What we do get is a preview of something bigger. Every state that hasn't passed a law like this yet is watching Kentucky right now, watching how this case plays out, because it becomes the blueprint. Get the law right, and maybe a kid somewhere else gets protected before anything happens to them. Get it wrong, and you've handed prosecutors a weapon broad enough to end a career over a relationship that was never anything but kindness. So here's what I want to know from you. If you found out your kid's teacher had late-night calls with them that you didn't know about, would you want the system to act immediately, the way Kentucky's new law lets it? Or does a law this new, with a word this undefined, worry you more than it reassures you? Tell me where you land, because this is exactly the kind of law that's coming to a lot more states next.